or reading the bare provisions of the Civil Procedure Code, and we are starting from Order 1, that is parties to the suit. Those who are appearing for the Jharkhand Judicial Service or preparing for the Jharkhand Judicial Service, the preliminary exam is on the 10th March. So let's start. Have a extensive reading of all the acts, that is Civil Procedure Code, Criminal Procedure Code, Indian Evidence Act, Law of Contract, and Indian Penal Code. These are the 5 law papers we have to read. So let's start with the Order 1. Now, Order 1, parties of suits. Now, Order 1, Rule 1 says who may be joined as plaintiffs. All persons may be joined in one suit as plaintiff where A. Any right to relief in respect of or arising out of the same act or transaction or series of acts or transactions is alleged to exist in such person, whether jointly, severally, or in the alternative. So, any person or all person may be joined in one suit as plaintiff where there are conditions. Number one condition is that any right to relief in respect of or arising out of the same act or transaction or a series of acts or transaction is alleged to exist in such person, whether jointly, severally, and in the alternative. And condition number B is if such persons brought separate suit, any common question of law or fact would arise. And then the multiplicity of proceedings will vitiate the cause of administration of justice. That's why this conditions has been laid down that if such person brought a separate suit, any common question of law and fact would arise. Now, Rule 2 says power of court to order separate trial. Where it appears to the court that any joinder of plaintiffs may embarrass or delay the trial of the suit, the court may put the plaintiffs to their election or order separate trials or make such other orders as may be expedient. So, Order 1, Rule 2 says, where it appears to the court that any joinder of the plaintiff, if the plaintiff is joined in the suit, it may embarrass or delay the trial of the suit. The court have option. The court may put the plaintiff to their choice or their election, that it is their sweet will to continue with to add them as a party in the ongoing proceeding or brought a separate suit or order a separate trial, or the court direct that a separate suit be brought by that plaintiff or make such other order as may be expedient. Now, 3 says who may be joined as defendant. Order 1, Rule 1 says who may be joined as plaintiff. 2 says the power of the court to order separate trial. Rule 3 says who may be joined as defendant. All persons may be joined in one suit as defendants where any right to relief in respect of or arising out of the same act or transaction or a series of acts transaction is alleged to exist in such persons, whether jointly, severally, or in the alternative. And if separate suits were brought against such person, any common question of law or fact would arise. The language is entirely same with Rule 1 and Rule 3. Only in case of 1, it is the plaintiff, and by the plaintiff the suit is brought. And in case of Rule 3, it is the defendant, and against the defendant the suit will be brought. Now, there are some state amendments. We don't have to read that, I think. Now, if anyone want to read that, if anyone watching from that particular area, I'm zooming that portion so that he can pause the screen for a moment and read that thing. Now, 3A. Rule 3A says power to order separate trials where joinder of defendants may be embarrassed or delay the trial. So, in Rule 2, we have read power of court to separate trial. This is in case of plaintiffs, and 1 is related to the who may be joined as plaintiff, 2 is power of court to direct separate trial for the plaintiffs, 3 says who may be joined as defendant, and 3A says power of court to order separate trials where joinder of defendants may embarrass or delay the trial. So, where it appears to the court that any joinder of the defendant may embarrass or delay the trial of a suit, the court may order separate trials or to make such other order as may be expedient in the interest of justice. Now, in case of defendants, may order separate trial or make such order as may be expedient in the interest of justice. So the difference between rule 2 and rule 3a is that in rule 2 the plaintiff has a choice, but in case of rule 3a, in case of defendants do not have a choice. If we look to rule 2, see, the court may put the plaintiffs to their election, but in case of rule 3a there is no mentioning of the election or choice of the defendants. It simply says that the court may order separate trials or make such other order as may be expedient in the interest of justice. Now, coming to rule 4, court may give judgment for or against one or more of the joint parties. Now, what is that? Now, order 1 rule 4 says judgment may be given without any amendment. A, for such one or more of the plaintiffs as may be found to be entitled to relief, for such relief as he or they may be entitled to, and against such one or more of the defendants as may be found to be liable according to their respective liabilities. Now, if any party do not adduce any evidence and at the first hearing the court sees on the face of the record that judgment may be given without any amendment, to whom, in favor of whom judgment may be given, for such one or more of the plaintiffs as may be found to be entitled to the relief, for such relief as he or they may be entitled to, and against whom the judgment may be given, against such one or more of the defendants as may be found to be liable according to their respective liabilities. This is order 1 rule 4. Now order 1 rule 5, defendant need not all the relief claim. This rule 5 specifically says that it shall not be necessary that every defendant shall be interested as to all the relief claimed in any suit against him. If there are several defendants, it is not necessary for all the defendants to be interested in the entire claim of the suit. He may be joined as a defendant for a portion of the claim. Now, orders 1 rule 6 says joinder of parties liable on same contract. Now, the plaintiff may, at his option, join as parties to the same suit all or any of the persons severally or jointly and severally liable sorry, on any one contract, including parties to bills of exchange, hundies, and promissory notes. So, if all the persons are parties to the same contract, the plaintiff has an option to brought a single suit against them all and make all of them defendants in the suit. Rule 7 says when plaintiff in doubt from whom redress is to be sought. Now, order 1 rule 7 says it is doubtful to the plaintiff from whom redressal or compensation. Now, in that order 1 rule 7 says where the plaintiff is in doubt as to the person from whom he is entitled to obtain redress, he may join two or more defendants in order that the question as to which of the defendant is liable and that to what extent may be determined as between all the parties. So, in that case, the plaintiff has an option to add all the defendants in that suit, and there will be an issue framed on the point that who is the ultimate person or exact person is liable and what is the extent of his liability, that will be defined by the court. Order 1 rule say 8. Now, one person sue or defend on behalf of all in the same interest. Now, this is called we know it, order 1 rule 8, representative suit. Now, order 1 rule 8 sub rule 1 says where there are numerous persons having the same interest in one suit. First, sub rule 1 says where there are numerous persons having the same interest in one suit. Now, clause A says one or more of such persons may, with the permission of the court, sue or be sued or may defend such suit on behalf of or for the benefit of all persons interested. So, clause A says where one or more of such persons may, with the permission of the court, sue or suits or may defend such suit on behalf of all or for the benefit of all persons so interested. And B says the court may direct that one or more of such persons may sue or be sued or may defend such suit on behalf of all or for the benefit of all persons so interested. So, in clause A, first of all, it is order 1 which is representing the concept of representative suit. Now, order 1 rule 8 sub rule 1 says that it is of numerous persons having the same interest in one suit. Now, Order 1, Rule 8, Subrule 1, Clause A. In this case, Clause A's case, it is one or more of the persons may with the permission of the court. And Clause B says the court may direct. So, if the party wishes to file or defend a suit brought or defend a suit in representative capacity, he may do it he may seek a leave from the court, or giving the facts and circumstances or considering the facts and circumstances of the case, the court may also direct. It is the discretionary power of the court. Now, Subrule 2 says the court shall, in every case where the permission or direction is given under Subrule 1, at the plaintiff's expense, give notice of the institution of such suit to all persons interested, either by personal service or where, by reason of the number of persons or any other cause, such service is not, or for any other cause such service is not reasonably practicable, by public advertisement, as the court in each case may direct. So, Order 1, Rule 8, Subrule 2 says, if the court either gives permission or directs the plaintiff or the defendant to be sued in representative capacity, so in that case, it is the duty of the court. The court shall, in every case, what will do? Court will direct or give discretion at the plaintiff's expense. Court will order that at the plaintiff's expense, give notice of the institution of such suit to all the person interested, either by personal service or where personal service by reason of the number of the persons. If the number of persons is too much, then personal service is quite impracticable. So in that case, it may short for the newspaper advertisement by at the plaintiff's expenses. Now, Subrule 3 says any person on whose behalf or for the benefit or for whose benefit a suit is instituted or defended under Subrule 1 may apply the court to be made a party to the suit. So, after getting notice, if anyone thinks that he must be joined as a plaintiff or the defendant in that ongoing proceeding, otherwise his interest will not be represented properly, so he may apply to the court. So any person on whose behalf or for the benefit or for whose benefit a suit is instituted or defended under Subrule 1 may apply to the court to be made a party to the suit. Now, Subrule 4 says no part of the claim in any such suit shall be abandoned under Subrule 1, and no such suit shall be withdrawn under Subrule 3 of Rule 1 of Order 23. No agreement, compromise, satisfaction shall be recorded in any such suit under Rule 3 of that order, that means Order 23, unless the court has given at the plaintiff's expense notice to all persons so interested in the manner specified in Subrule 2. So, Subrule 4 of Order 1, Rule 8 says that if there is a fundamental change in the decision making process of the plaintiff of the defendant or the defendant, that is what is fundamental change? That is withdrawal of the suit, or there is agreement between the parties, compromise or satisfaction agreement between the parties. If these fundamental decision making process is made while the ongoing while the civil suit is pending, in that case also, just like Rule 2, at the plaintiff's expense, the court will order that at the plaintiff's expense, all the person interested must be made aware of that fundamental change that is going to take place in that proceeding. And after that only the court will allow the whatever it may be, the abandonment of the suit or the withdrawal of the suit or this agreement, compromise or satisfaction, whatever it may be. Now, Subrule 5 of Rule 8 says where any person suing or defending in any suit does not proceed with due diligence in the suit or defense, the court may substitute in his place any other person having the same interest in the suit. So, in representative suit, if the person who is representing all the parties to the suit, whether as a plaintiff or the defendant, if he is not diligently performing his duty, or the court raise a suspicion about his conduct in conducting the suit, then the court have the power to substitute that person with another person with same interest in that suit. Now, Subrule 6 says a decree passed in a suit under this rule shall be binding on all person on whose behalf or for whose benefit the suit is instituted or defendant, as the case may be. Now, in the case of representative suit, so the outcome of the suit is binding on all the persons, whether he is a plaintiff or the defendant who is represented by a representative. Now, in this case, there is a explanation. What the explanation says? The explanation says, for the purpose of determining whether the person who sue or be sued or defend have the same interest in one suit, it is not necessary to establish that such person have the same cause of action as the person on whom behalf or for whose benefit they sue or suit or defend the suit, as the case may be. So, the interest of the party, it is not necessary that the interest of the party shall be identical with the other parties. Okay, so it is not necessary to establish that such person have the same cause of action. Identical cause of action is not necessary. Substantially same interest is enough. Identical cause of action is not necessary. Substantially same interest is enough to participate in a representative suit or brought as a representative suit, or in that case, for that matter, defending a representative suit. Now, coming to Rule 8A, Order 1, Rule 8A says that power of court to permit a person or body of persons to present opinion or to take part in proceedings. While trying a suit, the court may, if satisfied that a person or body of person is interested in any question of law which is directly or substantially in issue in the suit, and that it is necessary in the public interest to allow that person or body of person to present his or its on that question of law, permit that person or body of persons to present such opinion or to take part in the proceeding of the suit as the court may specify. So, Order 1 Rule 8A says that power of court to permit a person or body of persons to present opinion or take part in a proceeding. In this case, this person is not a party to the suit, but for the ultimate disposal and final disposal of the case, it is necessary to add that person or to take his opinion under consideration. Then the court may, if satisfied that such person or body of person is interested in a question of law. Now, in this case, Order 1 Rule 8A, this is not a question of fact. It is saying about question of law, which is directly and substantially an issue in the suit. Now, if there is a question of law, then concerned authorities will be made as a party, made a party to represent their opinion about that point of law, so that the legislature's perspective must be represented properly. So that's why, if if the court is satisfied that a person or body of person is interested in any question of law which is directly and substantially an issue in the suit, and that suit is necessary in the public interest to allow that person or body of person to present his or its opinion on that question of law, because if it is not because that person's or body's opinion, if not taken under consideration, then the decision will affect a larger section of the people. So, at the beginning stage, it must be heard. All the parties interested must be heard. And we are talking under Rule 8A, Order 1 Rule 8A, we are talking about question of law. Always remember that fact. Then we are talking about question of law, then this rule will be remembered easily. So, permit that person or body of person to present such opinion and to take part in the proceeding of the suit as the court may specify. Now, very important, that is Order 1 Rule 9, that is misjoinder and non-joinder of parties. So, what and non-joinder of parties? No suit shall be defeated by reason of misjoinder or non-joinder of parties, and the court may in every suit deal with the matter in controversy so far as regards the rights and interests of the parties actually before it, provided that nothing in this rule shall apply to non-joinder of a necessary party. So, misjoinder means mistakenly joined as a party, or a person who actually is a defendant is by mistake added as a plaintiff, and vice versa. These are the case of misjoinder. And non-joinder means whose who has not been made a party in the suit, that is non-joinder. Now the rule 9 says that a suit shall not be defeated or dismissed by reason of the misjoinder or non-joinder of the parties, and the court may in every suit deal with the matter in controversy so far as regards the rights and interest of the parties actually before it. So misjoinder and non-joinder of parties is not a fundamental defect in the proceeding, and the court may continue with the suit irrespective of the fact of misjoinder and non-joinder of the parties to decide the matter which is actually before it. But there is a proviso, and which is the most important thing under this rule, that is that this rule, nothing in this rule shall apply to a non-joinder of a necessary party. Now in case of necessary party, if the necessary party is not added in the suit as a party to the suit, whether it may be a plaintiff or the defendant, whatever it may be, necessary party, who are the necessary party? Necessary parties are the persons in whose absence a suit cannot be decided properly. So these are the persons who are necessary party. So that's why this rule, in case of non-joinder of necessary party, court cannot overlook the matter and go on with the proceeding. As simple as that. Now, Rule 10 says suit in name of wrong plaintiff. So, what will be the consequences and the circumstances if the suit is brought against in the plaintiff, or I mean in the plaintiff of a wrong plaintiff, in the name of a wrong plaintiff? Sub-rule 1 says that where a suit has been instituted in the name of a wrong plaintiff as plaintiff, or where it is doubtful whether it has been instituted in the name of the right plaintiff, the court may at any stage of the suit, if satisfied that the suit has been instituted through a bona fide mistake, that is a mistake which is bona fide, not mala fide, and that it is necessary for the determination of the real matter in dispute to do so, order any other person to be substituted or added as plaintiff upon such terms as the court thinks just. This is very simple. Now, in case of coming to sub rule 2 of rule 10, court may strike out or add parties. What is the striking out and adding parties? That is order 1 rule 8 sub rule 2 says the court may at any stage of the proceeding, either upon or without the application of either party, either the on the application of the party or without the application of the party, that is on suo motu basis, and on such terms as may appear to the court to be just, and their court may set also terms which the court thinks is just, order that the name of any party improperly joined, whether as plaintiff or defendant, be struck out, and that the name of any other person who ought to have been joined, whether as plaintiff or defendant, or whose presence before the court may be necessary in order to enable the court to effectually and completely adjudicate upon. That is the main terminology, that is effectually and completely adjudicate upon. So if necessary party is not added, just we have just read that provision, proviso of the rule 9, if necessary party is not added, then the court will not effectually and completely adjudicate upon the matter. So that's why the court cannot overlook the matter of non-joinder of necessary party. Now coming to this provision, now striking out and adding parties, where are we? So they have been joined, whether as plaintiff or defendant, or whose presence before the court may be necessary in order to enable the court to effectually and completely adjudicate upon and settle all the questions involved in the suit, be added as a party. So it may order striking out or be added as whether as plaintiff or defendant of the suit, and this power lies with the court. It may do it on the application of the parties or on suo motu basis. Even that's also, in both the cases, the court may set conditions with that order. Now sub rule 3 says no person shall be added as plaintiff suing without a next friend or as the next friend of a plaintiff under any disability without his consent. So in case of a person who is under a disability, what are the disabilities? Now Limitation Act says the minority, insanity, idiocy, these are the three main disabilities which have been recognized by the civil law. Now in that case, no person shall be added as a plaintiff suing without an next friend or as the bring a suit by him or against him. It is necessary to name the next friend of that person. Next friend is necessary in case of disability. Otherwise he cannot be added as a plaintiff suing without a next friend, or in case of a defendant also. Okay, as the next friend or the plaintiff may or disability without his consent. Now, sub rule 4 says where defendant added, plain to be amended. Now, where a defendant added, now in an ongoing proceeding, it turns out that a necessary party as a defendant has not been made a party to the suit. So, in that case, the court will fail to finally and completely adjudicate the matter. So, court may order, or court will order to add that party as a defendant. In that case, where the defendant is added, plain to be amended. Where the defendant is added, the plain shall, unless the court otherwise directs, be amended in such manner as may be necessary, and amend copies of the summons and of the plaint shall be served on the new defendant, and if the court thinks fit, on the original defendant. So, if a party is added as a new defendant, then the plaint and the summons, everything will be amended and his name must be added on it, and the new plaintiff or this I'm sorry, the new defendant will be served with the amended plaint and summons. The new defendant will get the notice of with the copy of the amended plaint and the summons, and if the court thinks, it may also order to serve the copies to the original defendants to make them aware are the who are the actual parties before the court. Now, sub-rule 5 says, subject to the provision of the Indian Limitation Act, Section 22, the proceeding as against any person added as defendant shall be deemed to have been begun only on the service of the summons. Now, Section 22 of the Indian Limitation Act says, is the general rule that when the party is added as a defendant, the time will reckon again, the counting of the time will be from the date has been added as a party to the suit, or added as a defendant to the suit. But there is exceptions also. If the court is satisfied that there is a bona fide mistake, the court may also order that his addition of the party will be treated from the institution of the suit. That's also possible. Now, 10A, Order 1 Rule 10A says, power of court to request any pleader to address it. Now, in this case, the court may, in its discretion, request any pleader to address it as to any interest which is likely to be affected by its decision on any matter in issue in any suit or proceeding, if the party having the interest which is likely to be so affected is not represented by the pleader. So, the court may at any stage of the proceeding sought help from an expert or a pleader in that field to resort for his opinion or for help. And that pleader must be an independent one who is not connected with the ongoing proceeding, whether from the side of the plaintiff or from the side of the defendant. Now, 11, conduct of the suit. Who will conduct the court may give the conduct of the suit to such persons as it deems proper. The court will decide who will conduct the suit. Now, Rule 12 says, appearance of one of several plaintiffs or defendants for others. Now, where there are more plaintiffs than one, any one or more of them may be authorized by any other of them to appear or plead or act on such order in any proceeding. And in a like manner, where there are more defendants than one, any one or more of them may be authorized by any other of them to appear, plead, or act for such other in any proceeding. So, this rule only says that where there are more plaintiffs than one, any one or more of them may be authorized by any other of them to appear, plead, or act for such other in any proceeding, and vice versa. In like manner, where there are more defendants than one, any one or more of them may be authorized. It is not mandatory that at a time only one person shall be authorized to conduct the suit. It may be conducted by several persons who are authorized by the other several persons who doesn't want to appear or conduct the suit, or for their personal reasons. Okay. Now sub rule 2 says the authority shall be in writing signed by the party giving it and shall be filed in court. Now these given by the other persons to him before the court. Now coming to Rule 13, objections as to non-joinder of misjoinder of parties. Now, in non-joinder of misjoinder of parties can be overlooked by the court, but non-joinder of necessary party cannot be overlooked by the court, because it will not help the court to finally and effectually and completely determine the suit. So, Rule 13 says all objections on the ground of non-joinder or misjoinder of party shall be taken at the earliest possible opportunity, and in all cases where issues are settled at or before such settlement, unless the ground of objection has subsequently arisen, and any such objection not so taken shall be deemed to have been waived. So 13 says, Rule 13, Order 1, Rule 13 says that if anyone having any objection regarding the non-joinder or misjoinder of parties, then he must make or raise that objection before the court at the earliest possible opportunity. Otherwise, it will be treated as that he waived or he accepted that misjoinder or non-joinder. Now, there is a proviso that in all cases where issues are settled at or before such settlement. Now, civil cases generally issues are settled. So, if anyone having any objection as to non-joinder of misjoinder of parties, it must be raised before the settlement of issue, and if the ground of objection has subsequently raised. If the ground of objection raised subsequently, it appears or turns out in the ongoing proceeding at a later stage of the proceeding that anyone must be added or have not been added, or mistakenly added at a different side, then only the objection can be raised when the situation arises. Otherwise, you have to raise your objection at the earliest possible opportunity. So this is order 1 of the civil procedure code. If we go through it in a fast manner. So order 1, that is parties to the suit or parties of suits. Now rule 1 says who may be joined as plaintiff. 2 says power of court to order separate trials. 3 says who may be joined as defendant. 3A, power to order separate trials where joinder of defendants may be embarrass or delay the trial. First 4.1 is plaintiff and separate trial, defendant and separate trial. Now coming to 4, court may give judgment for or against one or more of the joint parties. Now, defendant need not to be interested in all the relief claim, that is order 1 rule 5. Rule 6 says joinder of parties liable on the same contract that has been given, the plaintiff has been given the power to join all the parties binding under the same contract. Now order 1 rule 7 says the plaintiff in doubt whom redress is to be sought, then he can add all the parties and hand over the matter before the honorable court to decide who will be liable and to what extent. That is order 1 rule 7. Order 1 rule 8, that is representative suit, person suing or being sued on behalf of all the person. Now 8A says power of court to permit a person or body of persons to present opinion or to take part in a proceeding. That is, I have already mentioned that in the case of rule 8A, it is question of law and having general public is interested in that matter. In these situations only the opinion of the third person is relevant. Now order 1 rule 9 says misjoinder and non-joinder can be ignored, but non-joinder of necessary party cannot be ignored. Now rule 10 says suit in the name of wrong plaintiff, the court have the power and authority to substitute the name of the wrong plaintiff and in his place the right person must be added. And order rule 10.2 says strike out and addition of the parties court if it thinks fit. Things fit means having reasonable ground to believe that and it can also be done by on the application of the party or by the court suo motu order the striking out of the parties or addition of the parties. Now coming I mean rule 10 sub rule 4 defendant added. Now in that case this is very important, order 1 rule 10 sub rule 4, that is where defendant added, plaint to be amended. Now if the plaint is amended, the new defendant added will be served with the newly amended summon and amended the amended plaint. And if the court thinks, it may also order the original defendants who are also already on the record be served with the amended plaints. Now 10A says power of the court to request any pleader to address it. Now 10A says power of the court to request any pleader to address it. Now in that case, it is court is, if the court opinion that it must resort to some expert's opinion in that field, that is also senior advocates are also they are always helping the honorable courts, because it is the entire, we are part of the entire process that is called administration of justice. We are not, we are always, we are just on the same side. We are, it is not that the courts are on the opposite side of the lawyers. So but the pleader must be an independent one who is not in any way connected with the suit. Now conduct of the suit, it is the discretion of the court who will conduct the suit. 12 says appearance of one of several plaintiffs or defendants for others. In that case the authorization must be filed before the court. Now 13 says objection as to non-joinder or misjoinder must be raised at the earliest possible opportunity, otherwise it will be deemed to have been waived. And in all cases where the issues are settled before the settlement of issues, and the objection as to non-joinder or misjoinder if arises at a later stage of the proceeding, then when the objection arises or the circumstances appear before the person who have the objection, he may raise it even at a later stage. That's order 1 of the civil procedure code.